finally gave in. Thank you for the indulgence.
Well, it seems to be even hotter now than it was.
Yeah, it does. Anyway, good
You
afternoon.
know, sooner or later somebody's going to look at suing the court service. I'm not encouraging you to do that.
No. I just want to pick up on two final paragraphs of the judge's judgment before going on to make, as it were, our positive case on this matter by reference largely to our Skipton argument, I have to say. So it's paragraph 96 of the judgment, bottom of page 94. There's a couple of points made here. The judge was correct to reject the argument that the FCA scheme itself results in inherent unfairness. In my submission, there must plainly be a triable issue as to whether the scheme put forward by the FCA was sufficient to remedy the acknowledged unfairness in the specific relationship. So we will see that even at the level of 50%, there is still a very significant profit, and we would say an excessive profit, to the financial institutions from this business, and that remains an important factor in the overall determination of unfairness. It was the reason the relationship was unfair in the first place, and therefore it's critical to determine whether that level of commission, which is now sort of built into the FCA scheme, renders the relationship fair. We say that it doesn't, particularly when you look at the costs element, which is a thing I'll come to in a moment. So the judge sort of rather dismissed that, and in my submission he can only dismiss that in circumstances where he effectively delegates the determination of fairness to the FCA rather than takes it on board as the court. It goes back to that, in my submission, goes back to that paragraph 17 of Plevin distinction. So is it arguably unfair that a financial institution could still charge somebody 50%? In my submission, at the very least, there's a triable issue as to that. But of course, and I accept this, that has to be seen in the context of the fact there was a compromise agreement in relation to that, and that's what the judge goes on to say. He says this: it's difficult to understand the suggestion that the redress sum was substantially insufficient to remedy the unfairness in circumstances in which Mr. Harrop, with advice, accepted the offer of settlement. Now, that's a pretty critical point. He's obviously placing some significance on with advice, and the reason for that is probably clear, that it was relied on quite heavily, as one might expect, as one of the factors in Hollyoake, because clearly you just have to pause for a moment to think of the situation we're in. We're in a situation where you've got a consumer, obvious imbalance between the respective strengths of the parties. That consumer has already been on the wrong end of an unfair relationship created by non-disclosure of excessive commission. So the idea that that consumer all of a sudden becomes in a position to assess with any degree of accuracy or effectiveness whether what he is now being offered is fair, it is, in my submission, fanciful. So that's why you get to the importance of legal advice, and there was simply no evidence of any legal advice in this case. There wasn't any. What you've got is, it is true to say, FRS writing on behalf of Mr. Harrop, but I think the court can take recognition from its own experience. In fact, that's a claims management company. And of course, their interests will often be to get the matter sorted quickly, and not least because they can't, in fact, or they wouldn't, in fact, conduct the case going forward with litigation. So when you see that there is no legal advice, but there is, in fact, a claims management firm in charge, you ought to be, in my submission, the antenna, as it were, ought to be twitching rather than being calmed down by the presence of that party. But it's interesting the judge felt the need to refer to advice, but in so doing, in my submission, he's erred because he's relied on something that could not be relied on as being sufficient to permit Mr. Harrop to make a properly informed decision. So that's paragraph 96. para 99, then I just want to touch on quickly. The judge was entitled to conclude that Skipton was not required in concluding the compromise to disclose the actual costs that it incurred. That is not required by DISP 3. Well, that will no doubt echo with the court of the approach that Lord Sumption specifically said was wrong and that had been adopted in the Black Horse case. The fact that disclosure is not required does not wash away the unfairness of not providing it. Now, why will come in a moment. I've got some slightly more detailed submissions on costs, but costs feed into the whole question of whether profit was excessive, if excessive profit creates by its nature an unfair relationship, whether a party is in a position to make an informed decision about whether it's in its economic benefit to enter into an agreement or not. So, for example, I'm offered a product and I know that it's at a pretty standard market price, and general common knowledge would tell me that it was, reasonable profit margin, I want the product, I buy it. A wholly different situation arises where I've in the first instance been subject to non-disclosure, so that I've bought something in complete ignorance of what the real situation is. Then someone comes along to me, they say, okay, well, we recognise we shouldn't have done all that. So what we'll do is we'll give you 50%. But they don't tell me anything about how that leaves them, whether they're still wildly and excessively profitable at that level. And if I knew that, with or without advice, that would surely be relevant to whether I was going to accept that offer. If I had advice, no doubt that advice would ask that question. But Mr. Harrop didn't have advice of that kind. So we say the judge was taking a backward step, as it were, as far as approach is concerned, by taking the approach to disclose that he took. But in fact, the costs are relevant for reasons I'll come to in a bit more detail in just a second. I won't take too long on this section thing, by the way, but that is one of the points that I need to focus on. So I think I can take the rest by reference to our skeleton argument, if I may. And I don't need to repeat everything we said because I know you have it firmly in mind. The section kicks off at paragraph 35. That's page 41. And paragraph 35 simply sets the scene, acknowledges the jurisdiction, etc. Paragraph 36 I just want to take a moment on because it explains how we got to where we got to. So you may well have picked up on the fact that the grounds of appeal are initially premised on the basis that the correct approach was to decide whether there was an unfair relationship prior to the compromise agreement, and if so, what the remedy would be, and then only look at the compromise agreement as a matter of part and parcel of the remedy, if you like, not of the overall relationship. Following Smith, which made absolutely clear that compromise agreement of this kind is a linked transaction, we revised the approach to this appeal, revised the skeleton argument. There was a supplemental skeleton argument dealing with it, but of course one of the consequences of that is that there was no pleading as to the compromise agreement in the original pleading, so there are no facts there pleaded in relation to the compromise agreement. But in my submission we shouldn't be prejudiced in a case of this kind by the way that matter came around, but it's important that the court understands that's how it did come about. So paragraph 38, we deal with the fact that a variety of different orders have been made by the county court under section 140B to remedy unfairness. And we know, just going over the page at page 43 in that paragraph, the question of whether there had been unfairness and of the appropriate remedy, therefore absent a compromise, required to be addressed before the court could consider whether the terms of the compromise were fair and reasonable. So we say that follows just from the necessary sequence of events. What you're looking at is to see whether there is a fair relationship or a relationship that is not unfair once the compromise has been entered into, all of this on the assumption that it was, and therefore it's essential that you see what it is, what level of unfairness and so on you are seeking to remedy. And then underground 2.2, we make the point that given the decision in Plevin, the fact that the Commission sometimes exceeded 90% of the premiums and other exceeded 2/3 thereof, then a judge should have found the relationship was unfair. So in doing this step-by-step analysis, he should have first decided that. We say that essentially follows. And then in 41, we make the point about legal advice, which I've already addressed. I don't think I need to go further there, but you have it there for your record. There is a reference, if we just look over towards the end of that paragraph, to Lord Denning in Binder, also emphasising the conclusion that no undue advantage was taken of the borrower, who was informed by the fact that both sides in that case had been advised by competent lawyers.
We don't know anything about the advice he's received, do we? We don't know, starting at the top, we don't know what advice you've given him, we don't know what advice FRS gave. We are not in a position to inquire. They're a claims management company, but we don't know anything about their competence, legal or otherwise, apart from the fact that one might possibly have had a quick look at their website, which would be completely inadmissible. So how can we make a ruling or let that influence us?
I don't think you have to make a ruling on it, Lord. I think the reasoning goes in this way, that the burden, once unfairness has been raised, the burden falls to, in this case, Skipton, to show that the relationship was not unfair. Now, I wholly recognise that if simply nothing is said, that may not create a particularly high hurdle. But where prima facie facts and matters are raised, then that in my submission gives rise to the obligation for a full inquiry into the relevant facts. And we say here that there is no evidence at all of any legal advice being given. We've got.
Of course there isn't. It would be privileged, and you haven't chosen to waive privilege. If
The
any legal
fact
advice was given.
No, my lord, in fairness, the
Not only-
fact of legal advice would not be privileged.
Well,
The existence of it. So how do we talk about it, for example, in Binder, and how do we talk about it in Hollier?
is it?
The facts, of course, the full facts are not before the court. I accept that.
Do you accept that it was open to your client to go and get legal advice at any stage? Apart from that, you'd have to pay for it.
Well, that I can't comment on standing here, my lord, because, well, I simply can't, because I don't know the financial circumstances. It'd be completely wrong of
You
me.
just have to leave that out of account.
No, I don't think you do, my lord. I think that given the environment in which the court is operating, namely in the ambit of the Consumer Credit Act, the need to protect consumers, the court should be very slow to draw adverse inferences, if that's what's happening, from an absence of evidence at this very early stage of proceedings. Bear in mind that this is a case that went straight to summary judgment without a defence and a reply, in circumstances where the case hadn't even been pleaded in the way that it normally would be. Because that's nobody else's fault. That's not a criticism of anybody, but it's a fact. But where certain objective facts we can see. We know the sequence of events that gave rise to the compromising question. We know that a company called FRS was involved with that. We know that FRS is a claims management company. Now, we don't know the detail within that of the extent to which they were able to give legal advice or otherwise. But in fairness, from the experience of most of the people in this room, I would submit it's not too much of a leap to suggest that the fact of FRS appearing in this sequence of events is not enough to even establish a prima facie case that there was legal advice. And because of the burden of proof, that matters. And there's sufficient indication, for example, if you've got FRS writing back, the FRS are writing the claim letter, if you like, and then they're also writing a letter of acceptance.
Acceptance letter.
There's enough in I submit in that sequence to suggest that if there was, Alan and Overy were sitting at the side there, giving him detailed advice, we'd have heard about it. There'd have been something to indicate it. And indeed, if any High Street solicitor had been there. There's enough, in other words, prima facie, I submit to, for the court to say, well, there's at least a triable issue as to whether there was legal advice. I would say it falls the other way, that there's not a shred of evidence that there was legal advice. And absent that, let's just think how the sequence works. Legal advice is a factor in the fairness analysis. The burden has fallen to Skipton to prove fairness, so it's up to them to assert there was legal advice. It's not up to me to assert there wasn't. And they can't.
Accept that. I would accept that. There's no basis upon which we could find or assume that legal advice was taken.
So,
but what about, I mean, are we to assume that it was not open to Mr. Harrop to take legal advice?
well, again, looking at the probative sequence that has to be followed, Skipton would have to say, either say there was legal advice and prove it, or accept there wasn't. If the latter was the course of course that it took, it would have to say, but it was always open to Mr. Harrop because he had sufficient funds to do that. It's their burden. But I think an important point arises here, which I was going to come to later in a slightly different context, and that is, you would have expected a regulated entity such as Skipton compromising an agreement, compromising a liability or obligation in the way that they have chosen to do, to set out very clearly that legal advice was required. They know they're dealing with an individual. You really can discount the claims company, I would submit, for this purpose. They're dealing essentially with an individual. Saying, please ensure before accepting this offer that, or confirm to us that you have received legal advice, you would think would be one of the minimum things that they could do. And I would submit to the court that amongst other things, the failure to do that is an element of unfairness and continued unfairness in this relationship. In other words, jumping ahead slightly, this is all based on the premise that I'm wrong as to there being no binding agreement. If there is one, just because there is a binding agreement doesn't mean it was arrived at in fair circumstances with fair consequences. So a lot of the points that were made this morning about there not being a binding agreement would feed into a question about whether, if there was one, it was fairly entered into with fair consequences. So I think the answer to the whole legal advice thing is, one, it's up to them to say and prove that there was legal advice, and two, if they want to, because they can't do that, make a different point, then it's equally up to them. But what they cannot get away from is the fact they never required it, and it's very common in agreements of this kind in different areas, and indeed I think we might see it in the case this afternoon, to provide a stipulation as to the provision of legal advice.
They referred to going to the ombudsman free of charge. But okay, that doesn't deal with the legal advice point.
No.
But
the ombudsman is the alternative to accepting,
yeah,
isn't it?
But in the same way as you're implicitly accepting that if they had said you should take legal advice, that would be a feature that would weigh in the balance of the fairness of the relationship. Presumably you would also accept, although you'd say it's not sufficient, that the fact that they say you can go to the ombudsman free of charge if you're not content is a factor which on the jurisdiction point can be brought into account.
I must confess I struggle to see how that helps in the fairness analysis, because all you're doing is not helping with the assessment. You're just saying, if you choose not to do it, well, there's a route available to you. But it's not helpful to a consumer being told that this is the outcome of a regulatory exercise, here you are, these are the terms that that are being offered, to not say go and get legal advice as to whether it's a fair and proper offer, but up to you, take it or leave it. So I'm not sure that does weigh in the balance in all respect, but now I think paragraph 42 of our skeleton argument is one I'd just like to focus on for a moment, because it deals with this question of costs. So if this is at page 44, if we just pick it up about 5 or 6 lines down the paragraph, the learned judge and DDJ failed to analyse the factors to determine whether there are real prospects of success in persuading a court to exercise continuing jurisdiction by granting further relief. Such analysis required consideration of the nature of the unfairness, which corresponded with that in Plevin, namely that was still excessive commission, of the nature of the relief sought, and pausing on this for a moment, this is an important point, which was repayment of all premiums and compensatory interest on the basis that had disclosure been made, the claimant would not have purchased the MPPI. And that's an important point to dwell on, because when you're looking at fairness, as Lord Sumption identified in paragraph 18 of Plevin, any reasonable person confronted with the knowledge that these very high levels of commission were being charged would have declined to enter into the transaction. That's what Lord Sumption said. You just wouldn't do it if you'd known. So, in considering whether, following the compromise agreement, the consumer was in a fair position, one has to have regard to the fact that the starting point for all this, on the finding in paragraph 18 of Plevin, is that any sensible person simply would not have entered into this transaction in the first place. And so that all of these consequences never would have flowed. So you have to decide whether, you have to consider whether a consumer now confronted by the, if you like, the status quo of the reality that he has been disadvantaged over a considerable period of time, can fully appreciate, without being taken to Plevin and given advice as to the reality of the prospect of a fuller remedy, one reflecting the fact that he never would have entered into the transaction, whether that's a realistic possibility or it's not. How is a consumer to do that without legal advice? How is he even to begin that exercise? So we submit that's a very important point. It's important to look at how all this started and what the remedies that would be available, potentially available, to the consumer, in this case to Mr. Harrop, are, and so that to consider then whether he has got the knowledge to fully understand the implications of the decision that he is making, what he is giving up, what are the prospects of his getting it if he doesn't give it up, and so on. And then this paragraph goes on. And it concludes really that they should have determined from the above analysis that were real prospects of success in arguing the unfairness had not been sufficiently remedied by the payment under the compromise. Just bear with me one moment if you would. Yeah, so that of course feeds back to the legal advice point, and it gives content to the obvious need in these circumstances for that legal advice. So if we then go over to page 45, paragraphs 44 to 46, these are the paragraphs that in fact deal with the costs issue, which I had mentioned a moment ago. So we see paragraph 44, claimant argued this methodology, which included repayments of excessive commission over 50%, historic contractual interest and compensatory interest, was manifestly insufficient to remedy the unfairness because of the substantial discrepancy between the costs likely to have been incurred by the defendant and the amount that this permitted it to retain in commission. It goes back to my point a moment ago that there must still be inherent unfairness in a relationship where one party is getting excessive profits and in a way that the contracting party is incapable of informing itself about. So when paying a premium for insurance retention of 50% of its commission as to the non-insurer institution that sells the insurance is still a strikingly high figure. Here, after the compromise, they're retained as a result, just on the figures of this case, £2,021. According to the Competition Commission, cited...
How's that figure calculated, Mr. At 2021? I couldn't understand how that was calculated, looking at the...
I confess I didn't calculate that figure myself, so I'll...
looking at the letter that Skipton wrote. Premium is over 50%, was £652.30. So we thought the whole premium on that hypothesis was 1,304.60.
No, because some of the premiums are over 50% by a small margin.
Oh, I see. Yeah.
So you've got 50% as a block,
Yeah. Okay.
which I'm sure this spreadsheet would tell you, but it hasn't done so.
I wonder if I could ask Mr. Clark, who's much more versed in these things than I am, just to explain this calculation. Would that be inconvenient?
I'm sure Mr. Clark will be able to explain.
My lord, my lady.
Yeah.
I must confess it's a while since I did the calculation. However, the methodology I would have used would have been this. I would have looked at what the repayment represented as a percentage of the premium. So if, for example, the commission at the relevant date was 60%, then what would have been repaid would have been 10% of the premium, 1/6 of the,
Yeah.
and that's how it's been calculated.
I see. Okay. Thank you very much. That's very helpful.
Thank you.
Column 4 would, I think, on pages 249, 250, if someone set it up, would tell us what the premium, the total premium paid was.
Yeah.
Oh, that's from the commission charge.
Yeah.
Yes, yes.
So from the document that accompanied Skipton's letter.
Yeah.
Yes, that's right.
That's where you got it from. That was the source of the calculation, I'm told.
All right.
So,
Could I be very, just, could Mr. Clark just give us the equation on a piece of paper? So total premium, column 4, how he gets from A to B, and then I'll be completely happy and won't ask any more niggling questions on this particular topic.
I will endeavour to do that, sir. Electronically rather than on paper, unless you...
That's not an undertaking, probably.
and I was wondering whether
There's an unfair imbalance in the relationship.
it did occur to me that you were actually giving consideration for that promise. But,
Okay.
okay, so we'll deal with that. But the point, let's assume that that figure is correct. So that we go on, according to the Competition Commission, cited paragraph 5.56 of the FCA's consultation paper, which related to then proposed amendments to the district rules to introduce the unfair relationship, etc. A PPI distributor could cover its costs and make a reasonable profit from a commission equivalent to 16% of the premium. So distribution costs, even including, even adding on top of that a reasonable profit, comes to 16%. And yet, the commission paid is still amounting to 50%.
This goes back to what we were saying before the short adjournment, which is that in effect, stripping it away, your case is that all payments made under the systemic scheme are in effect prepayments because they don't go anywhere near looking at what unfairness is, because they all assume that you start at a 50% bar, and that can't be right.
Yes, it's just the sort of characterisation of them as prepayments. If the question is, do we say that 50% is too low to remedy the unfairness of the relationship, then the answer is yes. In this context, the question is if a consumer, notwithstanding that he knows he's being offered 50%, enters into a compromise agreement, can the court be satisfied that that is fair because the customer accepted the accepted the amount, and that's an end of it. And we said that simply can't be an end of it, in particular in this particular context, for the reasons I've said and will go on to say, including legal advice, understanding the implications, knowing what the larger remedies are, as we do here, but if without legal advice, a consumer wouldn't be in a position to appreciate that. And so that what these figures show, however they come to be, is that on any view of the matter, Skipton was still taking what could well be described, what a court could determine was an excessive profit, and the consumer wasn't in a position to assess that. And Mr. Clark reminds me that, of course, it might be right. In other words, the figure might not be as wrong as it appears if the costs of Skipton were in fact sufficiently high, such that the 16% industry average was not correct. So assume that Skipton actually gave us disclosure and those figures came out at 45%. Well, that might be a different thing. But prima facie, absent their discharging that element of the burden by telling us, knowing what the gross level of commission is and knowing what these average figures are in my submission, that is more than sufficient for a prima facie assertion that the relationship remained unfair even following the compromise agreement in respect of the imbalance between the parties and the excessive profit generated by Skipton. So those are paras 44 to 45, and we deal with the judgment there, which held that it was irrelevant, and I remind you of the error in approach of the judge there, where he said that because he wasn't required under the regulations, or they weren't required under the regulations to disclose, therefore it's not relevant to the analysis. In my submission, plainly is. And then we look at paragraph 46. Learned judge upheld the conclusion that the compromise was not unfair, absent disclosure of the, again going back to the distribution costs. And just a little bit lower, however, there must be a real prospect, this is the central element of the submission, of arguing that fairness required the defendant should not be entitled to retain commission that was more than 3 times the likely cost from a policy sold in circumstances where its failure to disclose the amount of the commission deprived the claimant of the ability to make a properly informed judgment about the value of the policy. And I would go then to just draw your attention really to paragraph 47, because this goes back to the point about the difference between the role of the regulatory guidance and the exercise of the court's discretion in assessing fairness. We've already touched on that a number of times, but for your reference, it's we address it in paragraph 47. And we come to the conclusion in paragraph 48 that a finding at trial the relationship was unfair would be almost inevitable. But we don't have to go that far, of course. At this stage, we can say there is at least a very strong triable issue. And the point is made that redress would have, that would have been awarded, but for the compromise, might have involved the repayment of all of the premiums. And again, there was an extreme discrepancy between defendants' likely distribution costs and the amount it retained. And there's an additional point, which is this, that all of this is on the premise that, of course, the compromise agreement was binding. We went through the various circumstances of that. And as I touched on a moment ago, if it's found against us that the compromise agreement was binding, that doesn't mean that the compromise agreement was fair. Or rather, that the relationship that subsisted following the compromise agreement was a fair relationship. So you have to look at how that settlement agreement came into being and what it told the consumer and what it didn't tell the consumer and what it should have told the consumer. So simply concluding that it was binding doesn't address any of those questions. So we already know one of the things it didn't address, and that was the question of legal advice. It didn't address with any clarity the options that were available. Now bear in mind, this is not an agreement between two equal contracting parties. So you might say, well, that's caveat emptor in the end. It's not up for us, the bank, to spell all this stuff out for you. But in my submission, when you're operating in this environment, it very much is for you to spell those things out. What potential remedies are you giving up? So first, I would submit actually that it is inherently unfair to be grafting on top of your regulatory, your apparent regulatory obligation, this kind of contractual waiver. So let's assume it's binding because one goes through the analysis and it is, but it doesn't make it fair. You shouldn't be doing this. And if you are doing it, you should only do it with the most clear of flags and signposts. And those signposts have to go to, as I say, legal advice, but they also have to go to the alternatives. What exactly are you giving up? So that a party can make that assessment. And none of that was present in this agreement. And so therefore we submit that there are a cluster of features that raise at the very least a prima facie case of an unfair relationship, that none of that has been effectively, I won't say rebutted because it's their burden, we need to keep that in mind, in any way addressed. All that's really said is, well, you haven't said anything, and therefore you know, the fact that it's our burden is irrelevant.
When you say does not draw attention to what is being given up, is that anything more subtle than the difference between total refund of premium and the DISP3 payment? Because that's obvious.
Well, as we say in the Skeleton argument, the judges around the country are awarding a whole variety of different remedies.
What do you say if you were drafting the perfect letter for Skipton, saying what had been given was being given up? What would it say?
It would say that the effect of a successful claim under 140B is to give the court a power to remedy the unfairness. There are a variety of ways in which the court can remedy that unfairness. They extend to situations where all of the premium might be returned. If this is a long, yours was a long agreement, because we know that, so that could therefore be a very substantial amount of money. All that the FCA is doing here is awarding this sum by reference to a formula that has nothing to do with your personal circumstances. You should take very careful legal advice before accepting this, because you might be giving up the opportunity of access to very considerable more compensation than this offers you, and so on. I'm not drafting completely on my feet, but it'd be those kinds of things. And you know, standing here, you may say, "Oh, come on," but you can't dismiss the requirement for those things lightly in this sort of environment. And in particular, when you look at what in reality the potential of which of what the claimant was in fact giving up, and again the discrepancy between the power of the two parties. It seems to me you have to tread enormously carefully in an environment such as this, and they haven't done that at all. You could, just looking at the sequence of events we went through this morning, it really appears that, as I say, this contractual provision is grafted on right at the end, without anything that signals its presence and its significance. And then all of a sudden, the consumer finds himself locked into an agreement, which he may not even have been aware of, but certainly not aware of the significance. So where we are is a situation where all of those factors matter. The burden is on the defendant, and we're at summary judgment stage when we haven't even finished pleadings. And in my submission, it would be wholly wrong to order or to allow summary judgment to stand in those circumstances.
Right.
Have a quick check. Yes, Mr. Clark reminds me that I just want to beg a bit of indulgence. There was a concern about the interaction with the Ombudsman this morning. Your Lordship referred to it as a bit of a niggle still. I don't think I quite satisfied that niggle. I'll put your Lordship's mind to rest. So I was going to ask Mr. Clark very briefly if he could just describe to the court how that works as between the redress and the Ombudsman, hopefully to settle your Lordship's nibble once and for all, if I may do that.
May I, my lords and ladies, start, however, by coming back to the question of the calculation.
Yes.
Because whilst the method I described is that which I would normally use when only given a redress figure, in this case, the amount of the premiums is provided in the table at page 249. There is no total in that table, but I suspect what I did was total all the premiums, because what they have retained is 50% of the premiums. So the formula is divide the total of the premiums by 2, and one obtains the figure for what Skipton retained.
Well, someone's got access to a working version of this spreadsheet. You can do the figures in 5 minutes. Someone from Skipton.
Well, I totaled them when I did the calculation.
You did it.
But if you want to check it, then that would be the way to check it. But that's what I believe I would have done in order to arrive at that figure. Because they starts off with £17 a month and goes up from there. So over the course of some
18 years.
yes.
No, it's 18 years of premium. No, it's not that long, is it? Because it stops in 14.
Starts in 2014.
Why have I got a bell ringing in my head about the scheme only applying to things after the 5th of April
2008.
2008?
2008 is the date on which new credit agreements came under unfair relationships. So old credit agreements came under unfair relationships. So the Act came in to regulate credit agreements that were entered into after the 5th of April 2007, and it was made retrospective on the 5th of April 2008 to cover credit agreements that were then still extant. This credit agreement, because it was still in existence at the 6th of April 2008, became subject to the regime
From inception.
from inception.
Okay, thank you.
The other point I just wanted to cover can be dealt with by looking at 2 documents. The first is in the second supplementary bundle at the back, and that is the introduction to DISP. Because this gives a very brief summary of the structure of DISP. Page 110. And you'll see there, this is the introduction to DISP. And it starts off by saying that this part of the FCA handbook sets out how complaints are to be dealt with by respondent, firms, and the Financial Ombudsman Service. So that is the nature of DISP. The word complaints, you will see, is in italics. And that is because it is a defined term defined by the FCA's glossary. I regret to say that the glossary, insofar as it defines complaints, is not in any of the bundles. I have it on the screen in front of me, and what it says is that in DISP, it means any oral or written expression of dissatisfaction, whether justified or not, from or on behalf of a person about the provision of or failure to provide a financial service which alleges loss and relates to an activity which comes under the jurisdiction of the Ombudsman Service. So one point that should be noted is that DISP is wholly integrated with the Ombudsman scheme. The DISP applies where there is jurisdiction for the Ombudsman, and as one can see in the introduction, chapters 2 to 4 of DISP deal with the rules in relation to the Ombudsman's service. The rules, chapter 1 of DISP deals with how respondents to complaints should deal with them, including under 1.4 how they should resolve those complaints. Hence the title Dispute Resolution Complaints Handbook. And if those complaints are unresolved, then under chapters 2 to 4 of DISP, they proceed to the Ombudsman. So it's not that the customer simply has the right to go elsewhere if they do not accept the offer that is made under DISP. Rather, if the offer is not accepted, the complaint is not resolved, and DISP will deal, and FOS will deal with unresolved complaints. So it's all integrated and a discrete scheme involving both the actions of the lender and the actions of FOS.
But it requires the dissatisfied party to refer it on to the financial ombudsman.
It does require the party whose complaint has not been resolved to refer the matter onto the Ombudsman. I fully accept that. But my point is that DISP envisages the Ombudsman and the actions of the respondent as part of an integrated whole, which is in contradistinction to moving outside DISP to referring a matter to the courts.
Yeah.
So I think those are, unless we can be of any further assistance, those are our submissions.
Thank you very much, Mr. Mann and Mr. Clark.
Thank you.
Yes, Mr. Butters.
Oh, yes, yes.
Yeah.
My lords, my lady, I'm conscious my learned friend has covered ground
Yeah.
that I cover also in my skeleton argument. I will endeavour not to simply repeat what he has said. I'm sure there will be some overlap. The way in which I intend to structure my submissions is first to make an overarching submission, first about the claim itself, and then how the complaint was resolved. I'll then make some outline submissions about the two regimes that are in operation here. On the one hand, a cause of action under sections 148 to C resolved through the courts, and on the other hand, what I would describe as a self-contained statutory redress process, namely DISP. I'll then move on to how the complaint was resolved in detail, in this case by reference to the operation of the rules, and that will set me up to deal with each of the three grounds of appeal. The claimant entered into a credit agreement with the defendant's predecessor in 2001, and the agreement was assigned to New Day in April 2014, and the assignment isn't relevant to this appeal. The claimant took the PPI policy out at the same time. This was a credit card agreement, so the way it operated is that the premiums were charged on a monthly basis, and the premiums were set by reference to a percentage of the outstanding balance on the credit card. So if a debtor was someone that paid the full balance off each month, they wouldn't become liable for PPI. On the opposite end of the spectrum, someone that paid only the minimum each month would then pay for PPI as a percentage of that outstanding balance. what we can see immediately from that, because of course the premiums were financed by the credit agreement, is that the PPI itself operated as a second compounding factor on any outstanding balance. There would be the operation of the interest on any outstanding balance, and then the operation of the PPI itself, and that would grow and grow if the claimant only paid the minimum off. And in this case, the average commission paid by the insurer to the defendant was 99.18% of the premium. No attempt has been made in this litigation by the defendant to justify its commission at all. My learned friend for Harrop has referred to distribution costs, but there is nothing in this appeal by which the defendant has sought to justify the commission. And in my submission, bearing in mind the instant of the burden of proof, one can take it that that is pure profit, 99.18%. And so as the balance potentially compounds, so does the income that the defendant receives from the PPI premium, but also the interest charged on that PPI premium, which is then capitalised each month. The defendant disclosed neither the fact nor the amount of commission. The fact of commission was not disclosed until the FCA redress letter in February 2021. The amount of commission was not disclosed until the defendant's witness statement in these proceedings. The claimant's evidence was, unsurprisingly, that if she had known about the commission, she would not have taken the PPI policy, and she brought this claim for return of all her premiums. But it's worth noting that if the alternative award that has proved attractive to county courts, return of the commission, were to be made in these proceedings, the claimant would recover 99.18%.
What was the insured event under this policy? When did it respond? When should it have responded?
Accident, sickness, or redundancy is the general purpose of this policy, and then it would pay off the balance or elements of the liabilities that the claimant had under the agreement. Of course, the fact that a consumer might decide not to take the policy if the commission had been disclosed was the reason for the non-disclosure in the first place. See here the observations of Lord Justice Males in Canada Square and Potter at paragraph 171, where he said any other explanation defies common sense, a judgment with which Lord Justice Flo agreed. And it's interesting because both Potter and Smith and RBS, another PPI case that recently came before the Supreme Court, are cases where the claimant received the FCA redress sum before bringing civil proceedings for the balance. And I can say that whereas in Potter quantum was agreed, in Smith, at first there was a compromise defence, as it happens at first instance, that wasn't pursued beyond appeal. But the district judge in Smith awarded full repayment of all PPI premiums in a judgment that was praised both by the Court of Appeal and the Supreme Court. And I make those observations because it certainly isn't the norm that a claimant receives the FCA redress and it stays there. There are a large number of claims, as one might imagine, that are brought and indeed do succeed where there's been that FCA payment. The Supreme Court in Plevin held that non-disclosure of excessive PPI commission in this sort of situation gives rise to an unfair relationship for the purpose of Section 140A of the Consumer Credit Act. And Lord Sumption held that the size of the commission is something that would cause a consumer to question whether the PPI policy was a sensible transaction to enter into, and disclosure would have allowed the claimant to make an informed judgment. That's paragraphs 18 and 20 of Plevin. I won't take you to those now. It's notable, however, that in Potter and indeed Smith, the court had to consider whether continuing non-disclosure beyond the non-disclosure at the outset relevant to the decision whether to take PPI could give rise to an unfair relationship. And the Court of Appeal in Potter held that it could, and that was the basis for finding that the continued non-disclosure represented a breach of duty for the purpose of section 32(2) of the Limitation Act, and that decision, in terms of the interpretation of section 32, was reversed by the, Supreme Court. But certainly the rationale for that aspect of the decision still stands. And then that's, by the way, paragraph 83 of Potter, judgment of Lady Justice Rose, as then was. That's AB 24, page 638. And Smith, paragraph 66, judgment of Lord Legate, AB 26, 732, 733. The continued non-disclosure by RBS after the PPI policy had ended, but the credit agreement continued, by itself gave rise to an unfair relationship, but also alongside the fact that there was still money outstanding in relation to PPI at that point in time. So on any view, the claimant had a very strong case for a finding of unfair relationship and recovery of between 99.18% and 100% of her premiums. And on first appeal, the judge held that the relationship was unfair up to the point of the compromise. See paragraph 38A, that's core bundle, tab 8, page 108. The particulars of claim in this case, and I think this might have been what my Lord Justice Stuart-Smith was referring to, did plead at paragraph 21, that's core bundle 177, that the settlement sum was insufficient to remedy the unfairness. I'm paraphrasing.
Could you just give me the page?
That's page 177
Thank you.
in the core bundle. And of course, at the stage of the compromise agreement, there hadn't been full disclosure of the amount of commission, and there still hasn't been any attempt to set out what the profit margin is, the submissions made by my learned friend. So that's the claim. If I can turn now to the two regimes, and if I can start with section 140A to C, you'll find the statute itself at AB 28741. And so it starts, section 140A1, with the opening words, the court may make an order under section 140B in connection with a credit agreement if it determines that the relationship between the creditor and the debtor arising out of the agreement, or the agreement taken with any related agreement, is unfair to the debtor. Pausing there, we can see from that that there is a discretion as to whether to make an order under section 140B. And that the power to do so is dependent on a finding in response to a binary question, is the relationship fair or unfair? And it's not the credit agreement that is being assessed for fairness. It's not the party's conduct that's being assessed for fairness. It is the relationship that is being assessed for fairness. And a relationship can be unfair because of one or more of the following. See subparas A, B and C. any of the terms of the agreement or of any related agreement, the way in which the creditor has exercised or enforced any of his rights under the agreement or any related agreement, and C, which is relevant for the allegation here, any other thing done or not done by or on behalf of the creditor either before or after the making of the agreement or any related agreement. The debtor is required to plead some facts setting out the cause of the unfairness alleged and must prove the facts upon which she positively relies. See Lord Legate in Smith at paragraph 40, that's AB 26725. I'm not going to take the court to all these passages because they're fairly uncontroversial, but it does set out how the section operates. Next, we have section 140B9, and that's AB 28, page 743, and that's the reversal of the burden of proof. If the debtor alleges that the relationship between the creditor and the debtor is unfair to the debtor, it is for the creditor to prove the contrary. As was said in
So it
Smith.
was 140B9.
9.
Thank you.
So, any facts alleged in support of the allegations at A, B, and C have to be proved by the debtor. But save for that, the burden is on the creditor to prove that the relationship is not unfair. In respect of those causes of unfairness listed at A to C, Lord Legate said in Smith at paragraph 22, AB 26, page 721, it would be hard to cast the possible causes of unfairness more broadly than this. And it's clear from Smith at paragraph 16 to 25, where Lord Legate sets out how the section operates, that the court must assess the whole relationship.
And in both cases that we're dealing with, they are now past relationships, and therefore we look at the position as at the end of the relationship.
That is right, my lord, yes. And that the court must take into account all matters it thinks relevant. See section 140A2, and that was emphasised in Smith by Lord Legate. So it isn't that the claimant has a cause of action in respect of each of the allegations that are made under A, B and C. The claimant has one cause of action alleging that her relationship is unfair. And the court can take into account all relevant matters, including the matters upon which the claimant relies.
When you say cause of action, sorry to be picky, do I understand that correctly to mean provided one or more of A, B and C of 140A are in existence, it is open to the claimant to raise the issue of unfairness in proceedings?
That is absolutely right.
Yeah.
Yes. And so there is no cause of action under section 140A that would appear like a breach of duty claim, such as there's a duty of disclosure, vis commission, there was no disclosure in breach of duty, that has caused loss to the claimant. That isn't the cause of action. And one can imagine that it's not the case here. The claimant's allegation relates solely to non-disclosure of PPI commission, but it's possible that an individual claimant may have an allegation in relation to non-disclosure of PPI commission. The claimant may have other allegations, perhaps an unfair rate of interest under subparagraph A, perhaps some complaint about enforcement, subparagraph B, perhaps the mis-selling allegations that we can see in the complaint letters in both cases could be raised under subpara C, and the court would have to undertake an assessment of the whole relationship. There'd only be one cause of action. In terms of how the court resolves countervailing factors that a creditor may rely on in support of its case that there is not, in fact, an unfair relationship, this was looked at by this court in the case of Scotland and British Credit Trust, in dicta of Lord Justice Kitchen, as then was approved in Smith at paragraph 56. So we can pick it up with the reference in Smith. That's AB 26, page 730. If there are matters relied upon by the debtor which point to the relationship being unfair, the court must clearly take into account any countervailing factors or other matters which put those matters relied upon by the debtor into perspective and so may affect the assessment. And Lord Justice Kitchen went on in Scotland, in part of the quote not cited in Smith, to in effect say that what the court will be looking for is whether the countervailing factor diminished or qualified the impact of the matters relied upon by the debtor.
What does that mean, impact? I thought you were going to come to that. I can understand what's being said up until then. Lord Justice Kitchen is not saying, is he, that the matters raised by, let's call them the lender, has to go directly to the matter, to rebut the matter that's been raised by the claimant. What he's saying, surely, is you take an overall balancing, and things come into the balance if they tend to affect the weight of the argument or put up by the things that the claimants. I got lost about halfway through that sentence, but you know.
My lord, I take the point entirely. A countervailing factor that was of a different quality and bore no relation to the unfairness relied on, but which is considered by the court to have equal and opposite countervailing
you
weight.
just get to an end point where you say, taking all these matters into account, is this unfair?
That's absolutely right. That's how the Supreme Court resolved the approach to unfairness in Smith. My learned friend for Harrop has taken you to paragraph 17 of Plevin, where Lord Sumption set out the difference between how section 140A-C operates and how the rules promulgated by the Financial Conduct Authority operated. And that's really the first judicial recognition in clear terms of quite how differently these provisions operate to an ordinary claim for breach of duty. And then we get the observations of Lord Leggatt in Smith at paragraphs 46 to 47, and they're at AB 26, beginning at page 726.
Paragraph again, I'm sorry.
Paragraph 46
Thank you.
and 47. So the bank's argument in Smith was on limitation, and it was argued that time should run from the initial non-disclosure. And both this court and the Supreme Court were against the bank on that, and time runs from when the relationship ends. And what Lord Leggatt said at 46 was this: the reason why in this case the completed cause of action argument may seem appealing at first blush is that the facts resemble quite closely facts which could give rise to a cause of action founded on contract or tort of a type which lawyers are used to analysing in a way that is similar to the approach for which the bank contends. And then he sets out, you can see in the middle of that passage at Roman numerals Roman numerals 1, 2 and 3, exactly the point I was making. If there was a cause of action based on a duty to disclose, the cause of action would accrue on proof of breach of that duty. So 1, customer entered into the PPI and made payments. 2, the bank did not disclose. 3, had such disclosure been made, the claimant would not have entered into the PPI contract. That's not how the section operates, and that's what he goes on to say at paragraph 47. while the relationship between the creditor and the debtor arising out of the credit agreement is continuing, there is no set of material facts which, as a matter of law, constitute necessary and sufficient elements of the cause of action, such that if those facts are established, the claimant has an accrued entitlement to remedy under Section 140B.
How does that fit? How does that fit with him saying elsewhere, and you'll know exactly what I'm talking about, that unfairness can emerge at any point, or you can get to a stage of where unfairness emerges at any stage in a relationship. And at that moment, if the claimant were to bring a claim, they would be entitled to say, is unfair, the reference being to is unfair,
Yes, it's a new relationship each day.
or each payment, potentially each day.
Yes. So
Sounds a bit
each
like
day-
continuing nuisance to me.
each day, I remember many discussions about that. Each day, there is a new relationship. The facts are different because it's the relationship on Tuesday, not Monday. And therefore, the assessment of the relationship, where the relationship is ongoing, is made at trial. And the cause of action hasn't accrued, time hasn't run.
That last bit is difficult,
It may be difficult.
but it is what Lord Legate says.
It is exactly what Lord Legate said. It clearly caused difficulty. You can see the concurring judgment of Lord Hodge, where initially he was against us. But that is how the section operates per the Supreme Court. And so you can see, I hope, the relevance of that analysis to certainly grounds 2 and 3 of my appeal, because to what extent, and I'll deal with this in due course, can a compromise agreement that refers only to a PPI undisclosed commission complaint be said to cover a compromise of a claim under Section 140A(1)? And insofar as we then look at ground 3, one can understand the breadth of these provisions and how they operate. I'll now deal with some brief points in relation to DISP before I get into the detail of the rules, doing my absolute best not to go over old ground, as it were. But I say there is a clear contrast between how Section 140A operates and how DISP operates, and it's a point being made by my learned friend that the rules of DISP are exactly as Lord Sumption described the ICOB rules in Pleven. They lay down hard-edged requirements promulgated in advance by the FCA, enforceable by an action sounding in damages. And as I've said, DISP is a self-contained statutory redress process. And when a firm is operating under it, it is no more undertaking an assessment of fairness such as the court would under Section 140A than it is performing the process of contractual offer and acceptance. And much of the confusion in this case arises in my submission because the amendments to DISP Act 3 that deal with undisclosed commission came into force as a response to the Supreme Court's decision in Pleven. And my lords, my lady, you've been taken to the provisions of DISP that refer to Section 140A, an unfair relationship. But actually, what the court has to do in my submission, in a case such as ours, and also I believe Harrop, is look at what the rules actually do in a case where there has never been any pleaded case or evidence that the defendant intended to depart from the presumptions or could have departed from the presumptions. And what we see then is that the rules operate in an entirely mechanistic fashion. They require the presumption of an unfair relationship if commission is over 50%, but actually what that means is, when you look at the next rule that's relevant, is it requires payment of a specified sum calculated by the statutory method. So in fact what's happening is, if commission's over 50%, the default position is redress of commission above 50%. and there's no pleadings or evidence that the defendant was or doing anything otherwise or could have done. And that is quite at odds with Section 140A. And the fact that Section 140A might be the origin of the rules is neither here nor there once they're enforced and operating in that mechanical fashion. And it is of relevance in my submission, before I go on to look at the detail of those rules, to observe that one of the FCA's objectives is to secure an appropriate degree of consumer protection. And in my submission, it's difficult to see a clearer example of the FCA seeking to fulfil that objective than in these rules. Of course, that is something that the rules have in common with Section 140A, which clearly has a consumer protection objective. And here we have a situation where the claimant was legally unrepresented and a consumer at the time of the compromise. I absolutely adopt my learned friend's submissions that a CMC is to be disregarded for this purpose, clearly not competent to advise on the scope or effect of a waiver, and indeed the presence of a CMC may indicate that there is an opposite incentive being applied to the claimant. Whereas the defendant was a multinational bank using documentation doubtless drafted by commercial lawyers, and the asymmetry of that position chimes with what Lord Sumption said in the opening words of paragraph 18 in Plevin. That is an extreme inequality of knowledge and understanding. So, my lords, my lady, those are the opening observations, as I say, govern the interpretation of the relevant provisions and the actions of the defendants in this case. My first ground of appeal is consideration, but that depends on how the rules operate. And I make the point in my skeleton argument that my learned friend, Mr. Clark, for Harrop has made, that there is a coherent whole when one looks at this, with the FOS following on from an unresolved complaint that is first made to a respondent. And see here, DIS 2.8, and that's at AB 44, page 917, which makes clear that the FOS can only deal with a complaint after the respondent has responded, or if the respondent has failed to respond within 8 weeks of the complaint. So there's absolutely no room for a complainant to first go to the FOS per that rule.
So what's the point about there being
It's just
direct access to the FOS?
I'm merely making the point about the structure of how the rules operate. So the respondent's duty to investigate a complaint is triggered upon the receipt of a complaint as defined in the FCA glossary, and learned friend Mr. Clark read that to the court. It's actually in my learned friend's skeleton argument at paragraph 57. For these purposes, complaint is any expression of dissatisfaction from a person about the provision of a financial service which alleges that the complainant has suffered financial loss and relates to an activity of that respondent which comes under the jurisdiction of the Financial Ombudsman Service. So any complaint about a financial service alleging loss means that if the complaint letter of 2018 had said no more than the PPI policy you sold me has ripped me off, that would be sufficient to engage the jurisdiction of the DISP rules and the requirements on the respondent firm to investigate. The detail of the 2018 letter is neither here nor there so far as engaging the jurisdiction is concerned. The letter is, as you've probably seen, very similar to that in Harrop, there's a series of mis-selling allegations. There's then reference to undisclosed commission, and the claimant, I say understandably, seeks all her premiums back. There is reference in that complaint letter to section 140A, and there is reference to the Plevin v Paragon Commission complaint issue. In my submission, the reference to section 140A in the complaint letter is no different to the references in DISP that I've touched on a moment ago. It doesn't indicate that the claimant is intending to bring a civil claim under sections 140A to C. In any event, the letter is written by a claims management company. It's referring to the fact that at that time, there were in operation DISP rules that express themselves as having their origin in section 140A. It's, in my submission, clearly a complaint seeking a resolution within the DISP process.
It's clearly a complaint, and it's clearly under section 140 because it says so on page 24 near the bottom. But it's also more, with all those references, it's a more broadly based complaint, isn't it?
It absolutely is, but for this purpose, what I'm saying is it's a complaint seeking resolution within the DISP process. And the reference to 140A shouldn't throw the court off, because the court can see that the relevant DISP rules in relation to undisclosed commission refer to section 140A. But as I said, they are doing different things, in the words of Lord Sumption. Now, upon receipt of the complaint, the defendant came under a number of mandatory duties under DISP 1.4.1R, and they're at AB 43.864. I know my learned friend has taken you to them, but they are at the core of what the defendant was doing.
Could you just hold on a second?
Yeah.
Page,
Once, page 864.
thank you.
Once a complaint has been received by a respondent, it must investigate the complaint competently, diligently and impartially, etc. And we know there was an investigation. And then 2, assess fairly, consistently and promptly the subject matter of the complaint, whether the complaint should be upheld, what remedial action or redress may be appropriate. And then 3, offer redress or remedial action when it decides this is appropriate. And then 5, comply with any offer of remedial action or redress accepted by the complainant. Short point on construction of those rules. It's obviously the case that the redress that must be offered further to subsection 3 is the redress that the respondent firm has assessed as appropriate under paragraph 2C. So insofar as a firm has assessed the appropriate redress as payment of X under paragraph 2C, then there's clearly a duty to offer that very redress under subsection 3. And you can see that those general provisions of DISP provide for a process of offer and acceptance. That is not contractual in nature. It is part of the self-contained statutory process. And there's good reason for that, as my learned friend has explained, because the FOS is only going to be interested in unresolved complaints. And that's why you have the wording at the bottom of the redress letters saying if you are still dissatisfied, you can go to the FOS. And that the words dissatisfied is no accident, because that relates back to the definition of complaint, which is any expression of dissatisfaction. Dispatch 3 is the rules by which a firm should investigate and assess PPI complaints as part of its overarching duty under DISP 1.4. And a broader point about Dispatch 3, and I don't want to get bogged down in all the various provisions, I think this is uncontroversial. A firm assessing a PPI complaint has to assess it in 2 stages. First, if there's a mis-selling complaint, look at the mis-selling complaint. And only if either 1, the firm considers the complaint is truly only about commission, or 2, it has concluded in respect of a mis-sale complaint, or it has not concluded in respect of a mis-sale complaint that the complainant would not have taken the PPI policy but for the breach, then it goes on to consider undisclosed commission. Putting it in a more attractive way, if the firm upholds the mis-selling complaint, concludes that the complainant would not have taken the PPI policy but for the breach, then the default remedy is repayment of all premiums, and there'd be no need then to go on to consider the commission complaint. So in effect, it's only if a mis-selling complaint is not upheld that the firm then goes on to consider the commission aspect. And that's exactly what happened here. And you can see in the bundle there are 2 letters, April 2018, where the defendant, first on behalf of the insurer and then on behalf of itself, rejects the mis-selling complaint and then says you may be due redress under FCA rules and guidance in respect of undisclosed commission. We'll get back to you. Pausing there, the rules were actually in force at that stage. So I'm not quite clear why there was a delay, but it may have something to do with the assignment to new date. Anyway, it doesn't arise on this appeal.
Sorry, why do you say if they conclude that the person would not have bought the policy, the default position is return of all premiums? Can you just give me the reference?
That is DISP Act 3.71 to 3.72E, and that's AB 46954. And it does then say the remedy is not exhaustive. That's DISP Act 3.81E.
Can you give me that once more?
And that's
3.7.
3.7.1 to 3.7.2E, AB 46954. And then remedy not exhaustive, DISP Act 3.8.1E, that's AB 46959. We can then pick up the defendant's response to the claimant's complaint with those provisions in mind. And if we first look at the defence, you'll find that in Core Bundle, tab 16, page 180.
Yeah.
And you'll see it paragraph 2. About the 5th line down, the complaint was assessed under the Financial Conduct Authority's Dispute Resolution Complaints Rule, brackets DISP.
Sorry, I can't find that. You say it's page 180 of the core bundle.
Of the Core Bundle, yes. In self,
Yeah.
yes. We did file an amended bundle last week,
Yes, I think that's my problem.
principally because the defence was missing, my lady.
Yes, I think that might be it.
Yes.
Okay,
Shall I?
no, don't you worry, I'll have it elsewhere, I've got my
Yes,
note,
Sure.
that's fine, thank you.
So paragraph 2, the complaint was assessed under the FCA's dispute resolution complaints rules. That's dealing with the investigation of the complaint from the outset, including the missale. That's a general pleading. And then sticking with the defence, we have paragraph 3. Subsequently, on 1st Feb 21, Santander, on behalf of the defendant and New Day, wrote to the claimant, told her it had considered whether there was an unfair relationship, brackets, under DISP, arising out of the agreement because of the alleged non-disclosure of commission. And it's relevant that the defence was pleaded in that way with under DISP in brackets, because when we get to the defence to the allegation of unfairness at page 183, paragraph 13.
Well, I'm sorry to interrupt you, Mr. Butters, but is that it's what actually? I mean, it's not your defence, of course, not your document, but what the letter actually says is we've considered whether there was an unfair relationship arising out of the agreement under the Consumer Credit Act.
Yes.
So it's a bit equivocal, isn't it?
Well,
It doesn't
Well,
actually
what the
mention DISP, I don't think.
the letter goes on to refer to the FCA's rules and guidance. So in my submission is
Rules and guidance, yes.
absolutely clear when you look at the structure of the DISP rules that my learned friend has taken you to, that the DISP rules have their origin in a response to the decision in Plevin with regard to section 148, but then otherwise operate in a mechanistic fashion. And so I would say, my lord, in response to that the pleaded case demonstrates what the defendant was actually doing and resolves the ambiguity that might otherwise be apparent from the face of the redress letter. The defendant's telling you in this defence that when you see section 140A, it's a reference to 140A for the purpose of DISP, not for the purpose of a cause of action before the civil courts.
Right.
And we get paragraph 13, which is the defence to the allegation of unfairness, and this point is made, for the avoidance of doubt, if a borrower brings a claim to the court under the unfair relationship provisions, then A, they bear the burden of proving the facts which they say create the unfairness, and B, the lender is not obliged to make any presumptions as it does under DISP. So the defendant is pleading.
So that's definitely looking at the position under section 140A of the Consumer Credit Act.
Absolutely it is, and that's because it's defence to the claim.
Yeah.
And so the defence makes clear the distinction in that it's operating under DISP in the redress process, and now it's putting forward a defence to the claim. And then finally, if we look at paragraph 4 of the defence, page 181, the settlement sum, this is third line down, the settlement sum is the excess commission over 50% of the premiums paid plus interest and calculated in accordance with DISP. So the redress sum follows the DISP process.
Yeah.
And then for completeness, if we look at the defendant's evidence, we can pick up the statement of Julie Byrne in the supplemental bundle, paragraph 18, that's tab 2, page 10. And the last sentence, accordingly, SUK PLC on behalf of the defendant upheld the undisclosed commission complaint, and offered the claimant redress in settlement of that complaint. and then at paragraph 19, confirmation that the defendant's witness, Julie Byrne, understands the settlement sum was calculated by reference to excess commission over 50%, and that the method for calculation followed the FCA's proposed redress scheme. It wasn't proposed at that stage, as included in the FCA handbook at Dispatch 3. And then I'll come on to the letter itself in a moment, but the next port of call is the judgment on first appeal.
Sorry, and paragraph 20 says the settlement sum was offered on a final basis in settlement of the undisclosed commission complaint.
Yes. Yes. And my lady, you're right, it's notable that that is the extent of the settlement that the defendant's witness said had been reached. If we then go to paragraph 13 of the judgment below.
It had previously rejected the mis-selling complaint as being time-barred.
It had, but when you look at the structure of DISP, as I've said, my lord, it therefore was required to consider the undisclosed commission complaint. And there was a period of nearly 3 years between the rejection of the mis-selling complaint and then the defendant reverting to the claimant under the Dispatch 3 undisclosed commission rules. So paragraph 13 of the judgment, page 99 of the core bundle, that's tab 8.
This is Judge Owen's judgment.
Judge Owen's judgment, my lord, yes. It is clear from the respondent's defence and evidence that in fact the respondent was seeking to apply DISP 1, which required, amongst other matters, as a mandatory requirement, must the respondent to investigate the complaint which had been made, assess it fairly, consistently and promptly, and offer redress or remedial action when it decides this is appropriate. It is also apparent from the respondent's evidence that the way in which the respondents approached this task was in fact to apply Dispatch 3. So those were the findings of Judge Owen. There was no live evidence at trial, so Judge Owen was entitled to take his own view of the written evidence in my submission. And if we then go to page 103 in the core bundle, this is paragraph 22 of Judge Owen's judgment. And we can pick it up on the second line. I accept the appellant's argument that once the respondent assessed the appellant's complaint, whether under Dispatch 3, as in this case or otherwise, and determined that an award of redress was merited, as the respondent clearly determined in this case, it was legally obliged under DISP 1.4.13 to offer redress. The word must is used in that rule, which was not mere guidance, which rule was binding upon the respondent. So that's a finding, I say. First, clear on its terms that the defendant was under a duty to make an offer, but it must be a finding in my submission that it was a duty to offer the very redress that it had assessed as appropriate. See my earlier observations on the construction of DISP 1.4.1.
Duty is a confusing word here, isn't it? Obligation.
My lord, it's a statutory.
Well, particularly in circumstances where you're trying very clearly to distinguish between statutory regime, DISP, and common law.
Yes.
Things. What you really want is there's an obligation to pay.
I follow, and I've described this as duty in my skeleton argument. I'm content with obligation, obviously, because what I say is the defendant was obliged to offer to pay the redress sum that had been assessed as appropriate, and that was the redress sum without a waiver attached, because the finding is that the defendant was following Dispatch 3. And Dispatch 3 tells a respondent that it should pay the excess commission above 50%, and that's Disp 3.7.3A.3.E. Fairly tortuous. It's at AB 46, page 957.
If you could repeat that, 3.7.3a.
E. Sorry, 3.7A.3A brackets 3E.
Thank you.
And that's
I got lost.
AB 46 957. And it's worth having a look at again. It's headed Approach to Redress at Step 2. 3.7A2 is headed Duty to Remedy Unfairness, where the firm concludes in accordance with Dispatch 3.3a that the non-disclosure has given rise to an unfair relationship under Section 140A of the CCA, the firm should remedy the unfairness. Now, that's an example of what I was saying earlier. In my submission, the court shouldn't be moved by the language of 140A and remedying unfairness in that opening section, when what we know is that the defendant was not seeking to rebut the presumption of unfairness, and the presumption of unfairness directs the defendant to uphold the complaint, and the default redress position is then set out in the provision immediately following, which is commission over 50%. So how the rules are operating is, if commission's over 50%, you pay back the commission over 50%, and the rule is clear. It's 3.7A 3A, not 3, because it's a regular premium payment protection contract, so it's the provision right at the bottom. In relation to a regular premium payment protection contract, the firm should pay to the complainant in respect of each redress period a sum equal to an amount appropriately representing the commission paid in respect of that period, plus an amount appropriately representing profit share in respect to that period, minus 50% of the amount appropriately representing the total. And so we have evidence, pleadings and findings that that's what the defendant was doing. That is the redress that was assessed as appropriate, therefore, for DISP Rule 1.4.12c. And that means the defendant came under an obligation to offer that very redress under 1.4.13. I'll take you now briefly to the redress letter itself before coming on to the first ground of appeal.
Before you do that, I would just like to apologise to the court and say that I'm not intending to show any disrespect to anybody, but I am getting amazingly hot, so I've undone my... Thank you.
Sorry?
Would you like me to go to securities parties and families?
It's too late.
Well, I think the problem is that there are air conditioning units, but they make a dreadful noise.
I can sort it out for tomorrow.
Thank you.
Well, you can try if you could.
Today.
I mean, I will send an email when I get back after call to the manager asking for this to be dealt with. This has got to absolutely I'll say this in public in the courtroom, that this problem has been going on for nearly 12 months, and we're now told that the landlord will deal with it after the summer. In other words, we'll replace the business management system in September, and that's the best that the court service can do.
Well, I
I don't
apologise.
It's been in the Times, so I'm not telling you anything in the Times a couple of Thursdays ago about the heating and ventilation in this building.
Chancellor, Lady Justice Asplin is very, very modest. Would you mind if I took my robe off?
You
I'd
can,
be
do you want to take your robe
extreme
off?
if I took mine on too, because I'm beginning to feel
Yeah,
rather.
actually,
My lords, may I do the same?
if you want to take,
Let's all
if you want to
shed
take
a-
your
a-
gowns off, please do so. I think
I'm sure there are comments to be made about that.
maybe we just say tomorrow, just suits. No robes, okay?
Yes, thank you.
Even if something's happened, which it won't have done.
Thank you, I'm sorry to have interrupted you.
Not at all, my lady.
Very constructive.
Yes, indeed. So the redress letter is at tab 7, page 32 of the supplemental bundle. And my Lord Justice Flo has already pointed out the reference to the Consumer Credit Act in the second paragraph, and you have my submissions on that. The first paragraph refers to the rejected mis-selling complaint. The third paragraph, or the third substantive paragraph, the Financial Conduct Authorities provided rules and guidance which determine that to receive redress for the R&D aspect of your complaint, the store card has to have been opened after, and that's relevant to when Section 148 came into force, which is relevant because the FCA used that as the relevant period for the DIS rules as well. And then above the heading details of offer, you have the paragraph, in your case, the amount received as commission and profit share was more than 50% of the premiums you paid. Therefore, we'd like to offer you £830.84. And then the waiver wording, in full and final settlement of your complaint and any claim that you may have against SC, UKL and New Day in respect of R&D commission. But the preceding words make clear that the defendant is operating under DISP, and that's the finding of the judge below. If we move on then to the second page, this is continuing under the header details of our offer, and the first new paragraph starts with, in order to calculate the amount of redress due to you, we've carried out a reconstruction of your account. So that is wording in my submission entirely consistent with the defendant having upheld the complaint, assessed the appropriate redress as payment of £830.84, and regarding that as a sum that is due to the claimant, or in other words, the defendant is obliged to pay. And then at the bottom of that page, in bold, what you need to do. If you want to accept our offer, please complete the enclosed customer acceptance form and return it to us using the prepaid envelope provided. That is referring to the customer acceptance form that contains the waiver actually signed by the claimant as not a offer of settlement, but an administrative means of the claimant receiving payment. And of course that's consistent with the process envisaged by DISP, where there's an offer and acceptance. And as my learned friend has said, acceptance is important to show that the complaint is resolved, there's no longer dissatisfaction that could merit a onwards complaint to the Financial Ombudsman Service. And then we have the last line, which is again words of waiver. If you accept this offer, it will be in full and final settlement of this and any other claims relating to PPI you may have against SC, UKL and or New Day. There is then an FAQ that was enclosed. Oh, I should say, sorry, if we go to page 34, you'll see midway down under the heading Next Steps. We hope you'll be happy with this outcome, but if not, you have the right to refer your complaint to the Financial Ombudsman Service free of charge you'll need to do this within 6 months of the date of this letter. So that's standard wording informing the claimant of the ability to do that if dissatisfied. My learned friend in Harrop suggested that there is the offer of legal advice, or at least the advice to consider legal advice. It's not present, as I've read it, in our case. I think that might have been reference to the Taylor and GE case that has been relied on in the county courts. I would then introduce the FAQ that was enclosed with the redress letter. And if we can turn, please, to page 39 in the bundle. In fact, I do apologise. I'm going to take a slightly earlier point, which is at page 37. Just so it's clear that the defendant knew that it was operating under DISP and that section 140A and Plevin was merely the genesis of those rules. What is unfair commission about? This is about a court case, Mrs. Plevin, section 140A, Supreme Court agreed. Following this case, our regulator consulted and set out their rules and guidance. And of course, this letter followed the letter 3 years ago saying, you may be due redress, we'll get back to you. If we go then to page 39, there's a heading, do I qualify for redress? Halfway down the page. And again, note the wording, you are due redress if your agreement is within the scope and the combined commission rate plus profit share was over 50%. And then finally, to complete a look at the documents, page 41 is the signed customer acceptance form.
Yeah.
It's headed customer acceptance form. It's got Mrs. Christine Self, customer names, a reference number. You'll see below Mrs. Self's name, there's the offer, £830.84. There's the mechanics of payment and her account number, below which you can see authorising the payment. Please sign below in all instances. And then you've got the relevant waiver that the claimant signed up to. I understand that by signing below, I'm accepting the payment in full and final settlement of my non-disclosure of commission complaint, the complaint. And then it goes on to say, I agree that by accepting the payment, this fully settles the complaint against SC, UKL and or New Day, and that SC, UKL and or New Day have no further liability to me. If I raise further issues on the same or similar terms, I understand that SC, UKL and or New Day may choose to rely on this acceptance form as proof that such issues have already been settled. And then above the signature line, I want to accept the above offer of redress and full and final settlement of my complaint against SC, UKL and New Day.
With a small c. Does that matter?
Yes, well, I would say not.
You would say it's still referring to complaint as defined.
That would, I'd say, be the most obvious interpretation of this document.
You haven't brought a claim other than under section 140.
No.
So the question doesn't arise in either of the cases here.
No. No. But that's relevant to ground 2 of my appeal, the extent to which the waiver could be said to cover this claim. My lords, my lady, I move on then to the first ground of appeal.
Yep.
No consideration. And to a large extent, you've had my submissions on this because it's not disputed between my learned friend for Santander and I that if a party is already under an obligation to offer to pay a sum, that cannot stand as consideration for a waiver of a larger claim. And one can take the principle from Lord Justice Geoffrey Lane's judgment in Arale. AB4, page 70, if a defendant by paying compensation to a claimant is doing no more than perform an obligation already cast upon them by law, then that would not be good consideration for a promise by the plaintiff not to sue. And the short point is, the defendant was already under an obligation to offer to pay the redress sum under DISP 1.4.13 without the claimant giving a waiver. If you take the elements of the offer that the defendant was required to make under DISP out of the redress letter and the customer acceptance form, ignoring all the administrative words, you're left relevantly with just the waiver, for which there is no consideration. And in my submission, that is a way of illustrating the point. The defendant was making an offer within DISP. That's the finding of the judge.
We're not bound by that. I mean, it comes from the defence.
It does.
And all the reasons that led the judge. We would not necessarily be bound by that as a finding.
My lord, I think not, given that the judge himself was on appeal and making findings based on the documents. But in my submission, it must follow, and that's indeed why.
That's a different matter.
That's why I took the court to the pleadings and the evidence and didn't just say I've got this really helpful finding at paragraph 13. I say that the judge.
It's a nice one, if I may say so, but it's not necessary, and it's not binding.
No, but that is where the pleadings and evidence point. But the pleadings and evidence also explain the defendant's documentation. It explains why there's reference to section 140A within the documentation. In my submission, there can be no doubt what the defendant was doing. It was operating at all times within the self-contained statutory process, and that was the offer that it was required to make. An offer of redress with a waiver is obviously, as my learned friend said, an offer of redress of lower value than unconditional redress, and yet it was unconditional redress in my submission that the defendant plainly assessed as appropriate. And if this court were, for instance, to regard the position as being that, in fact, no, what's happened here is that the defendant assessed the appropriate redress as a contractual offer, and thereby there was an appropriate marrying up between the offer under 1.4.13 and the redress assessed as appropriate, because the appropriate redress was a contractual offer in the eyes of the defendant. Well, that is at odds in my submission with its pleading case in evidence, which is that it was following DISP, and DISP is clear that the requirement is to pay the commission above 50%.
And forgive me for being so slow, but I just need to be sure that I understand this. And the argument about obligation is 1.4.2 is a rule.
Yes.
DISP 3 is guidance, but 1.4.2 requires it to be followed. If the rule is breached, then section 138 gives a cause of action.
Yes.
Have I understood that correctly?
Not quite. And I can hear behind me the point, which is that DISP Act 3 contains some guidance, but the key provisions upon which both myself and the appellants in Harrop rely are evidential provisions, and evidential provisions are rules. The distinction between an evidential provision and a rule denoted by the letter R is that only rules denoted by the letter R are actionable for breach of statutory duty under section 138D of the Financial Services and Markets Act. The evidential provisions are still rules. But yes, certainly, my learned friend in the Harrop appeal makes the argument that DISP Act 3 itself generates an obligation to pay the sum, and I happily adopt those arguments, but I have a more specific point, to some extent arising from the fact that this is a case that's gone to a preliminary issue trial and there are some findings and we're further down the path in terms of evidence. I say you can go one step further and look actually at the rules that are actionable under DIS 1.4.1, because those were the general rules that the defendant was operating under, and DISBAP 3 was enacted in order to set out how a respondent firm should undertake the DIS 1.4.1 process where it receives a PPI complaint. And as my learned friend has pointed out, breach of DISBAP 3 can be relied on as tending to show breach of DISBAP 1.4.1. One point I would make, I would also submit, as my learned friend has, that it's not necessary for the legal obligation that the defendant comes under, which thereby negates consideration, to be an obligation that is actionable. It is sufficient that it is a legal obligation, although here, the particular duty that I rely on is actionable. And I set out some examples in my skeleton argument, one of which was expressed by my lady this morning. What if the claimant had scribbled out the waiver wording and said accepted not in full and final settlement or as part payment? Well, in my submission, the defendant would still have a duty to comply with that acceptance because it was making an offer under DIS 1.4.13, and upon acceptance, it was obliged
To pay promptly.
to pay promptly.
Under 5.
Yes, and if the defendant refused to pay, the claimant could bring an action under section 138D, and the elements of that...
It's under 138D sub 2 of the Financial Services and Markets Act.
That's right, and the elements of that cause of action...
Contravention of rule. So that's...
Yes, that's exactly right, my lord. And the elements of that cause of action would be there's a statutory duty to pay,
Under 1.
it was breached, it's caused me loss. There would be no element of a contractual analysis in that cause of action.
Well, the subsection itself contemplates that the failure to comply with a rule or contravention of a rule, which this would be, is itself a breach of statutory duty.
Yes, absolutely. Another another example would be simply an offer that didn't contain any waiver at all. I mean, you could imagine the exact same documentation with the waiver wording deleted, and the analysis, if following acceptance the defendant failed to pay, would be exactly the same. It would be surprising if a completely different analysis applied because there was waiver wording, then somehow leading the claimant down a contractual path to recover the money. It just demonstrates in my submission that this is a self-contained statutory process, and a contractual analysis doesn't come into it, but nor, as I've submitted earlier, does the analysis that the court would bring to bear under section 140A come into play. You look at the rules and you see where they take you in my submission. My lords, my lady, there's a second limb to my consideration ground, which is that in any event there was no dispute to pay the redress sum, and to that extent it could be seen to be almost admitted. I'm conscious I don't want to go over ground my learned friend has already covered, and there's no point really in this ground of appeal if the defendant was under a duty. So I'm making this submission on the premise that the court is against me on the duty point, but I say first, it doesn't appear to me disputed between the parties that where there is no dispute as to the liability to pay a liquidated sum, payment of that sum cannot stand as consideration for waiver of a larger claim. Now, the claim that is alleged to have been waived is a claim under sections 140A to C, and I accept that's an unliquidated claim. But the principle doesn't depend on an analysis of the claim that is waived. The principle depends on analysis of the claim that is not disputed or admitted. And that claim relates to the complaint within the DISP process, and that is a liquidated sum because, as I've said, the defendant never sought to rebut the presumption, has never set out that it could have done so. And there's only one figure that can be spun out. You put the claimant's account details in, it gives you a figure, and that's a liquidated sum.
So to following that through, if they had challenged the presumption, but said, despite that, we'll offer you the DISP sum anyway, then this argument wouldn't be open to you.
It would be more difficult to make the argument evidentially.
Yes, evidentially.
It may be that the claimant would ultimately obtain a finding that, that what the defendant was actually doing was not challenged.
But it is important, if not critical, to your argument.
Yes.
That this is an admitted sum because no one has picked up on, no one has challenged the presumptions, and therefore DISP 3 gives you a figure.
That is absolutely right. Yes. Yes. And I think the point is taken by the respondents in Harrop. Well, it can't just be an admitted sum if there is no potential liability at the end of it. And what I'm certainly not saying is that the admission was made in respect of a potential liability under an order made by the court further to section 140B. The admission was made, or the amount was not disputed, in respect of a liability arising within the compass of the DISP rules. And of course, one can understand why a defendant may decide not to rebut the presumption or adopt a different approach to redress than the default rules. There's no evidence that it could have done otherwise. But if, say, the defendant had decided not to follow DISP 3 and made no offer at all in respect of the undisclosed commission complaint, then the claimant could have complained to the Financial Ombudsman Service. The claimant could have brought an action under section 138D. In both those scenarios, it is almost certain in my submission that the minimum that would be awarded by the FOS or in the 138D would be the DISP 3 figure. I mean, the claimant could theoretically seek to get more, but that's the base level that one would expect to be awarded. And so then one can understand why a respondent firm, looking prospectively to where they may end up, decides the best way forward is to admit that the sum is due under the default DISP 3 provisions. And in my submission, we can see that that is what happens. So it's not an admission in respect of no potential liability in the future, and it's not an admission in respect of 140A. It's an admission within the compass of the DISP system. And in my submission, what the defendant has done is really no different to the various check cases that are referred to in my skeleton argument and my learned friend's skeleton argument, where the court has in effect found that despite the use of waiver wording, the defendant was in fact doing something different and admitting that a liquidated sum was paid, and opportunistically, if you like, adding on a waiver. And it's no surprise that as a defence to a subsequent claim, the defendant relies on the sanctity of a compromise. But unlike the example of the builder's cases where there may be a dispute about what the appropriate price should be for the work, here we have a set of mechanical rules that produce one figure under a statutory redress process. And there's never been any suggestion that there's any dispute about the defendant's liability for that figure within DISP, and therefore it cannot stand as consideration for a waiver of a larger claim. And I do say the remedy was in the defendant's hands. The defendant could have offered more than the DISP figure. Now, I'm certainly not submitting the defendant. It's the 10% point, my lord, but I'm certainly not suggesting that the defendant could insert that into the correspondence we see here, and that would be sufficient for a bona fide compromise that would stand the test under section 140A. In my submission, if a respondent firm wished genuinely to settle a section 140A to C claim, then what would potentially be required is, at the very least, advice to take legal advice, but a proper settlement agreement, and of course the offer would have to be made in separate correspondence, setting out this is what is due to you under the scheme, we're going to offer you more in full and final settlement. And this is touching now on ground 2, but you would presumably also need a pretty detailed recital of the facts upon which the settlement is based, not least because what you're not settling is a non-disclosure of commission breach of duty claim under section 140A. You can only settle, for the purpose of this claim, a section 140A claim, and that is a claim in respect of one relationship which may have many factors bearing on it. So that's straying into ground 2. I'm simply making the point, theoretically, it's possible for the defendant to offer more in return for a waiver of a further claim. But that's not what the defendant did. It relied on the very sum that it didn't dispute and it accepted was due under the statutory process. So on that ground also, there's no consideration for the claimant's waiver. That brings me on then to ground 2, which is that the waiver does not cover the claim. So this necessarily applies if you're against me on ground 1 and consider that there was consideration. I say it doesn't cover the claim that's before the court. You have my submissions already that the appropriate document to look at is the customer acceptance form. That's the contract that the defendant relies on. You'll find that at supplemental tab 8, page 41. And the relevant wording, therefore, appears to me to be, below, please sign in all instances. I understand that by signing below, I am accepting the payment in full and final settlement of my non-disclosure of commission complaint, brackets, the complaint, and then it's the complaint that is the subject of the waiver wording immediately above the signature. So non-disclosure of commission complaint. My primary case is that those words do not cover any civil claim.
Sorry, do not cover?
Any civil claim before the courts. That they are restricted to the DISP process. My secondary case is that even if that wording can be interpreted as extending to a civil claim, it doesn't cover this claim, a claim under sections 148C of the Consumer Credit Act. The general principles of contractual interpretation I don't think are in dispute between the parties. Of course, the relevant law and regulatory background is attributed to the parties for this purpose. The first point I'd make is that it's not for the claimant to make sense of the waiver were it not to cover a civil claim, or were it not to cover this claim. It may be that in those circumstances the waiver has little meaning. But if the correct interpretation is that it doesn't cover a claim, I say so be it. And that was the approach of Lord Justice Stevenson in Raleigh.
Yeah.
And we can pick that up at A468. And it's the left-hand column. And at the beginning of the marked up passage, he's referring to two documents. A was the receipt for the payment under the ordinance, and B was the waiver. And he says, but the words of B do not necessarily mean the same in the receipt given by the defendant to the Northern Assurance Company as in the receipt given by the plaintiff to the defendants. In the latter, they may be coloured or limited by the introductory heading and all of the other words of Part A preceding them. And I agree with my Lord, the Master of the Rolls, in thinking that they are. If they are ambiguous, they must be construed contra proferentum. And he goes on to say that he would uphold the appeal both in terms of the waiver being limited to the ordinance and also on the grounds of contra proferentum. But he then says, I appreciate that the narrower construction of Part B makes it unnecessary, though I'd not agree that it becomes meaningless. So there is Lord Justice Stevenson acknowledging the possibility that restricting the waiver in Raleigh to the ordinance would render it meaningless. That much troubled Lord Justice Geoffrey Lane, and he dissented on that issue. But there was a majority, Lord Justice Stevenson and Lord Denning, in favour of limiting the waiver in that way. But going back to this case, I say, for what it's worth, there is a possible meaning to the waiver if it is so limited, and that is that the defendant may have sought absolute assurance that the claimant wasn't going to pursue the matter further to the FOS. Now, it'd be a slightly unusual situation because the complaint would have been accepted for DISP purposes and therefore would be seen as resolved. But of course, there could then be further complaints. Oh, you didn't calculate the DISP 3 figure correctly. And in fact, if you correctly calculated it, the figure should have been £1,500 or the like. So one could possibly attribute a meaning to seek to prevent any further complaints around undisclosed commission to the Financial Ombudsman Service. And my secondary case is, of course, the defendant may have wished to preclude a claim under Section 138D, subsection 2 of the Financial Services and Markets Act. So it's not without meaning if it doesn't cover this claim. My primary position is that doesn't matter.
No.
On any view, the waiver cannot cover a Section 140A claim because of the nature of a Section 140A claim. The words non-disclosure of commission complaint are not capable of extending to preclude a claim alleging an unfair relationship. Take the example of the claimant who has two allegations of unfair relationship, the undisclosed commission allegation, but also an allegation of an unfair rate of interest. Let's imagine that the claimant herself had those two allegations in this claim. There would be no grounds to say that the waiver compromised that claim. It would be a claim alleging an unfair relationship, and the undisclosed commission complaint would be no more than an allegation in support of that unfair relationship alongside the allegation of unfair rate of interest. And what the court would have to do is assess the whole relationship, taking into account all relevant matters, and applying such countervailing weight, if any, that it thought appropriate to the fact that the claimant had recorded her agreement to wording of settlement in respect of the non-disclosure of commission complaint. And that may be resolved, see my ground 3, along the lines that it should have no impact whatsoever and the claimant should succeed on her unfair relationship claim as a consequence of the non-disclosure of commission and potentially the other allegation as well. Or, in a different context, though I say not this claim, the court may say, well, actually, the agreement the claimant appears to have signed up to does have some countervailing weight, and then there's an overall assessment as to whether all the factors give rise to an unfair relationship. But what the waiver would not have done is preclude the claimant bringing a claim under Section 140A. Now, my lords, my lady, is there a different consequence when you strip out that other allegation and you focus on this claim, which I accept relies solely in support of an unfair relationship on the non-disclosure of commission? Well, in my submission, it's the same point. The waiver still doesn't cover the claim because the claim is a cause of action alleging an unfair relationship. And all it means is that the court's assessment of the fairness involves one factor and the alleged countervailing factor, as opposed to two factors and the alleged countervailing factor. But the analysis as to whether the waiver covers the claim cannot change. And the fallacy behind the argument that the waiver covers the claim is the same fallacy in my submission that underlied the argument of RBS in Smith, that limitation ran from the point of non-disclosure. A claim under Section 140A relying on undisclosed commission is not a claim for breach of a duty of disclosure causing loss.
It's invoking the court's discretion to look at a relationship.
Absolutely is.
But you do bring a claim because you say, when you look at it, we want a remedy.
You do bring a claim, my lord, yes. And obviously it's possible, though more difficult than in a standard claim for breach of duty, for the court to grant summary judgment against a claimant on an unfair relationship claim. Imagine if the defendant had paid the claimant all her PPI premiums back plus interest, and then she were to bring a claim alleging an unfair relationship relying solely on undisclosed commission. Well, then the court would be able to look at the allegation of unfair relationship and the payment of full damages would be a rather weighty countervailing factor that would justify strikeout of the proceedings. It's not that the court would forever be involved in resolving these cases at trial, but where the claimant brings a claim alleging an unfair relationship, insofar as that claim is capable of surviving a strikeout, because, as in this case, the claimant says, I've received redress under the FCA scheme, but it's not given me all my money back, it's not resolved the unfairness, the relationship remained unfair after the payment of redress under DISP, then that is a claim that plainly satisfies the test and one that should go to trial for resolution. And that tells the court in my submission that the waiver cannot cover the claims. It doesn't go close to seeking to preclude an action under section 140 A to C. My lords, my lady, the next step in my analysis, if you're against me on that point, is that applying the usual principles of contractual interpretation, but also looking at the Arale case, the object or genesis of the redress letter and the contract with which we're concerned here, the customer acceptance form, was the self-contained statutory redress process, DISP, and therefore that informs the analysis of the objective meaning of the contract, and that would direct the court to conclude in my submission that the waiver is properly limited either to the DISP process or to a claim under section 138D. And of course, a claim under section 138D in circumstances where what the claimant is alleging is, you had a duty to me under DISP which was breached in or about the provision of redress, would be exactly the sort of claim for breach of duty that both Lord Legate and Lord Sumption held up in contradistinction to the way that section 140A to C operated. And so, in my submission, Arale is a helpful case. It was decided before ICS and West Bromwich, but in my submission, went about the contractual analysis in much the same way. My lords, my lady, I've introduced Arale at shortly before 4:30. I wonder if that's...
Well, I was about to say, if we're going to look at Arale again, let's do it at 10:30 tomorrow.
Yes.
All right, thank you very much.
All rise if able.
Again, just to repeat, just business attire tomorrow, no robes. Okay, I think, because I suspect that even however much I shout at the court manager, he won't be able to do anything.
Court rise if able.